Um, a very good morning to all of you, and congratulations as coach for putting this together. I really want to pay tribute to Honorable Justice MN Venkatchaliah for his extraordinary contributions and this outstanding group of people who have assembled here to be part of this conversation surrounding the book. I'm grateful to each one of them. I know that Dr. Singhvi has to leave quickly, so as a part of his unbillable hours commitment, I want him to answer one question and then leave. Dr. Singhvi, you've been a distinguished lawyer and I'm sure appeared before Justice Venkatchaliah, and I've seen several judges in the course of your journey. What do you think are the most important qualities of a judge whose contribution and legacy will transcend his or her time in the bench and indeed make an everlasting legacy that generations of lawyers and judges will not only be inspired but actually aspire to imbibe those qualities? Over to you, Dr. Singhvi.
Friends, I realized that the contract with Samir was that we'd have a group photo of the release and then I would not interrupt the free flow of the panel. But Raj, whom I call, among other names, an extortionist, is also a very persuasive person. Now, it's an important question, and it is pretty much what I said earlier from the podium. Ask yourself, what are the one or two words which strike you when you think of MN Venkatchaliah? I have had the privilege of appearing before him, practicing before him. To me, and I think to a lot of others, the first word which will come is gravitas. A second word which will come is dignity. A third word would be the word I mentioned, grace. Others are, of course, very important. Sometimes they are a given or a taken. Highest form of integrity. Never the possibility of an allegation of bias. These are obvious qualities for a model judge. And I can think of few better models than Justice Venkatchaliah fulfilling them. You ultimately leave your mark in the judiciary by these qualities. And let me tell you that from the 50s, we've had many names which have exemplified these qualities. No doubt there has been a decline. There has been a decline in every facet of life, so there's no point blaming judges. There is a decline in our legal profession. There are decline in so many other sectors. But these remain eternal, permanent qualities, along with the quality of your writing, the commitment to the system. I remember, as a much younger lawyer in the 90s, how a combination of Justice Ahmadi and Justice Venkatchaliah worked for arrears reduction. I was privileged to be, as a young lawyer, part of a team of 2 Indian lawyers, 2 Indian Supreme Court judges, and 4 American judges. And we studied the Californian system, which is the origin of ADR. The global origin of ADR is the Californian system. And it is our report which ultimately, with a gap of time, led to the Section 89 enactment in the CPC, which gives a menu of ADR options. But the seed was shown because of a collegiality, despite differences, no doubt, in that era as in other eras, between judges, of the need to decongest and declog the system. And Justice Venkatchaliah was an integral part. In between was Justice Verma, and then there was Justice Ahmadi, the then Chief Justice. So I think, in a nutshell, to answer your question, just seeing Justice Venkatchaliah at work as a judge, and let me add, equally important as a non-judge. Grace in retirement is not easy. Just as grace in office is not easy. And I think few, but certainly Justice Venkatchaliah, have shone in both the roles. Of course, I have many happy memories. He would, when you would talk to him, he would speak slowly, because he'd be formulating the most lyrical prose in the process of conversation with you. You see his speech, it is always very refined, formulating, and he would be then, in his mind, coming up with new concepts. And he did that as a judge, he did that as a person. He had an open house after retirement. I have not had sufficiently large number of meetings. I would have liked to meet him more, but whenever I have seen him, heard of him, talked to him, I have found the same grace. And I think I hold that above all in esteem. Thank you very much. I'll hang on for a few minutes more and then go.
Thank you so much, Dr. Singhvi, for those wonderful comments, gracefulness, humility, and of course, the true pursuit of excellence as well. Let me move to Honorable Justice Indira Banerjee, former Judge, Supreme Court of India. Ma'am, as a judge, I'm sure you have perspectives about the way judges essentially not only serve as members of the judiciary, but also contribute to the advancement of law and justice. From the standpoint of a colleague, as somebody who has been on the bench, how do you see the role of a judge when it comes to so much of social expectations generated out of their work itself? There is no institution in the country which has generated so much expectations from its contributions. And from the standpoint of your own presence in the judiciary, how do you see that, and how you look at Justice Venkatchaliah's contributions in that context?
In 1987, when Justice Venkatchaliah was appointed Judge of the Supreme Court, I was a toddler in the profession, trying to find my feet at the Calcutta High Court. I did not have the opportunity to appear in his court. But in those days, we were advised to read the loose volumes of the Supreme Court cases and the All India Reporter. A judge is known through his judgments. And I had the opportunity to read his judgments. There were many judgments, erudite judgments, and some of them were in the news all the time. Union Carbide, A.R. Antule, Sheila Barse, Joginder Singh, so on and so forth. From 89-90 onwards, I started getting stray briefs in the Supreme Court to appear in matters which had their roots in Calcutta. And when I used to come, I used to sometimes walk into other courts. I walked into the court presided over by Justice Venkatchaliah, particularly when he was the Chief Justice of India. And I was really impressed by the manner in which he conducted court. I noticed that he was extremely courteous to the members of the bar. He did not enter into an argument with the lawyers, as we often do. He asked questions which were relevant. To say the least, he conducted his court with dignity. And grace, as Mr. Singhvi has said. And even standing in the court for a few minutes, you could see the erudition which was apparent from the questions which he put and the propositions of law and the precedents to which he referred. I wish I could have watched the proceedings longer, but being a first-generation lawyer and the daughter of a government servant who had long retired, belonging to the pre-pay commission era, I could not take the risk of missing a flight back or having to stay one extra day in the luxurious accommodation which was usually provided by the clients who briefed me here. I think he was an ideal judge, and all the qualities which have been mentioned are the qualities which any judge should, in my view, have. There is only one thing. So far as integrity is concerned, I don't think we need emphasis on integrity as a quality, because that is the very basic thing of a judge. And if there's a lack of integrity, then that judge has no business to be a judge.
Thank you very much, ma'am, for that wonderful set of candid reflections. Let me quickly move to Justice Waziri. Justice Waziri is a distinguished former judge of Delhi High Court. You know, two of the contributions of Justice Venkatchaliah, especially when he was in the judiciary, something that is not adequately spoken about. He, of course, spearheaded the efforts to address delays in the entire situation surrounding access to justice. The Supreme Court itself saw huge reimagination of court management system, and also something for somebody of that generation. He was an early supporter of technology. He embraced technology and strongly believed in the idea of technology contributing towards improving the efficiency of the justice delivery system. I would like you to briefly reflect on those two elements and, of course, share your own perspectives about Justice Venkatchaliah's contributions.
What Justice Venkatchaliah, when he came in, many thousands of cases were pending. You know, but by the time he left, the pendency was only 19,000 in the Supreme Court. That is truly a remarkable thing for a country so large that you could bring down the pendency to mere 90,000. Today we are in this range of 65,000, 63,000 pending cases in the Supreme Court. He streamlined the system of filing of cases and bunching cases together so that cases involving the same issue of law were decided quickly and disposed of. That's one aspect. The other was, he said he came to the view that it takes roughly 18 months for a case to get over in the Supreme Court. And this, if you bunch them together, they get disposed of faster. But now let me tell you a little more about the man himself. As Justice Banerjee said, I was a struggling lawyer at that time, toddler at the time when Justice Venkatchaliah became a judge of the Supreme Court. And from the same chamber, my senior, you've paid a tribute to my senior today. So whenever I would go to appear in his court, just to watch standing next to my senior, what struck me most was about grace of the judge. His immense knowledge, his immense erudition, his equanimity. And one never felt at all threatened or in a way different in his court. He would encourage youngsters to speak up something beyond asking for Passovers. If you were seeking a Passover, he would always ask you, little more, tell us what's the matter about. That was wonderful coming from him. You know, I'll add more to that. This book, this wonderful book which has been put together, edited by Mr. Vivek Debroy and Mr. Samish Kochar, it talks about the qualities of this great judge. But to be a great judge, you have to be a great human being. And those qualities we've talked about. Justice Venkatchaliah has retired. And what a legacy is left behind, both in terms of legal principles, as well as in his far-sightedness as to how the law will develop. Take, for example, the he thought about creating institutions which will be a great place for learning for judges. We have the National Judicial Academy in Bhopal. He ensured that it was up and running. Every year, hundreds and thousands of judges from all over the country, district judiciary and of the High Court, go there and try to keep abreast with the latest in the law, the latest developments in the law. They make friends for lifetime there also. You know, the beauty, the legacy he leaves is that he was so far-sighted in the sense that he could see, as one of the essays here by Mr. Sudhish Pai talks about, he could get a glimpse of the universal in the particular, of the future in the immediate. So when he, in his judgment about that Rajasthan versus some police officer thing, he talks about how a police officer must conduct himself in times of arrest. It's very interesting. He led the lines. Then very interesting, I was working as a junior at that time. His Renu Sagar principles, which Mr. Vakil has talked about. Those principles in ADR resolution, what he talked about at that time, public policy of India, now it finds reflection in fundamental policy, fundamental law of India. He could see that far. Yeah. He could see that far and establish those principles. These were universal principles he could see there. But one thing many people will not be knowing, and no history books will record these things. He had an amazing influence on people's lives. I'll give you one small example which will never be written unless instances like this are talked about. If I remember correctly, it was February of 1994. I wanted to do a course, read a course in Masters in International Law with particular emphasis on the emerging field of European Union law. I was looking for some guidance. So at the lunchtime, I walked up to the corridors of the Chief Justice's chamber and he gave a small parchi. I wrote my name on that. I was unknown to him. And within seconds, I was ushered into the Justice Venkatchaliah's chamber. His lunch was laid at the table. He immediately got up, walked up to me, and he says, "What can I do for you?" And I told him, "Sir, I wish to pursue this course. I want to read more about the law." He heard me out. There was a twinkle in his eye, and he just warmly hugged me. He just embraced me. And he said, "Son, what you are going to do is what I would have wanted my son to do." Then he sat me down, explained to me the new emerging world of European Union law, with at that time was maybe 15 countries, and how these countries have given up, have made their Supreme Courts virtually subordinate to the Court of First Instance and the European Court of Justice. And he encouraged me to go ahead and do the course. I did so. And I'm so much the better for that. And I thank Justice Venkatchaliah for that. See, it is instances like these where a person who would encourage anybody to walk up to him and speak to him and take his guidance. I'm indebted, and I'm sure he's influenced so many people in his life. Thank you.
Thank you so much, Justice Waziri, for those absolutely poignant reflections. For all the audience here, I must tell you that all the questions that I'm asking are out of syllabus. We did not meet before and plan to decide what questions. Thank you, Dr. Singhvi. All right, over to you, Mr. Behram Vakil, the co-founder of AZB and Partners. Behram, one of the things that many distinguished judges are known, especially, is that they end up specializing in a certain field of law. So if you look at, for example, Justice Krishna Iyer, to a large extent, we speak about his contributions to the human rights, expanding issues surrounding public interest litigation, equally Justice Bhagwati. But one of the remarkable qualities about Justice Venkatchaliah is that he straddled across multiple areas of law. He advanced public law. He had extraordinary contributions in private law, in commercial law, in taxation. So in many ways, he epitomized the kind of jurist who was comfortable at all areas of law and was operating at the highest level in advancing the impact of law. I want you to reflect about that role of Justice Venkatchaliah and of course more generally his contributions, especially in the field of commercial law and taxation.
Thank you very much. I think I cannot agree with you more. And I think it's already been said a couple of times. I think Dr. Singhvi mentioned it and Sameerji also mentioned that in some ways there's over-specialization now. So we've got into, you know, walls of specialization. And maybe it's my age, but when we started our practice, it was you had to practice across the board. So you went to court, you know, 3-4 times a week, at least when you were at Little and Company, that's what you did. And you did property and corporate and, I mean, across the board, everything. Whatever was given to you, you ran with it. And that sadly, I think the pendulum is swung too much the other way. I mean, you will have a strong view on it. But I feel, just very quickly, that the English system, where they still have a 2-year training contract, 4 different seats, you have to have a broad knowledge of the different areas of law, is a very, very good thing. So that you can have Renaissance men, as I think Dr. Singhvi mentioned, and certainly Chief Justice Venkatchaliah was, we've all said it, that the breadth of what he achieved, the breadth of his knowledge, the breadth of his judgments, all the way from human rights to Union Carbide. Of course, I had the privilege to study deeply for my article on arbitration, which it's unbelievable we are still struggling. So, I mean, Renu Sagar was so far-sighted. Renu Sagar led to 96 Act, led to the 2015 amendment, and then we still, with all due respect, have, at least to my knowledge, Alimenta Nafed is the recent judgment, which again takes us back a little bit. It takes us backwards, and so we are, you know, I know that there is a Law Ministry has set up a commission to make amendments to clarify these issues. So something that he could have the foresight all those years ago, in '94, we are still struggling with today. And I mean, even when Carbide, I mean, again, we were all privileged, we lived through that time. We know the torturous process that it went through. It's just amazing. It's amazing. And I think we should, and you are at the crux of that, we should focus on that and not have young lawyers, especially initially, let it be as broad as possible. I mean, how are you going to be a good lawyer if you've never stepped into court? I don't get it.
Absolutely, Meram. In fact, as a legal educator, I'm so conscious because I get worried when young first-year law students say that, you know what, I want to specialize in cyber law. I mean, this is deeply worrying when something like that happens. So we do encourage that, and I take your point. Let me move to Mr. Pradeep Rai. Mr. Pradeep Rai is a senior advocate in the Supreme Court of India. Mr. Rai, one of the extraordinary qualities of Justice Venkatchaliah, it is said, is about encouraging young lawyers. At a time when legal profession is somewhat not as democratic and inclusive it ought to be, at a time when more and more new generation of lawyers who are first generation lawyers who are entering into legal profession, a man like Justice Venkatchaliah was able to go beyond the traditional approach to looking at only those who have advanced standing in the legal profession, but is constantly encouraging young people. Please reflect a bit on that, and of course, in general, his contributions as well.
Sir, actually, Honorable Justice Venkatchaliah, he started his career as a police officer. He was the IPS officer because his father wanted him to join police service prior to joining legal fraternity. But he did not like it and he left. He joined the profession. There are few examples that one, he is the founder of National Judicial Academy, so that reflects that how much he was into the education, not only for the younger generation, but also for the judges. When he became judge of the High Court, he was third in seniority when he was picked up for Supreme Court, because those days the then CJI, Justice R.S. Pathak, he was in a visit of different high courts and he was trying to find out good talents. So one opinion from almost entire high courts of South was that nobody is better than Honorable this gentleman. When then Chief Justice Sen, he requested him to meet, and he said that why don't you call on the Chief Justice of India? He said, no, I am not in habit of calling on anyone, and he did not meet him. Thereafter, when he was even being picked up for the Supreme Court, again the then Law Minister Shiv Shankar requested him that, sir, you should just call on Honorable Prime Minister Rajiv Gandhi. He said no. He said, should I communicate this to Honorable Prime Minister? He said, yes, of course. But he was picked up and he received a call from our former Attorney General, then Attorney General, Mr. Parasran, and he joined the Supreme Court. The one fact which is very important and which is a lesson for almost entire fraternity, that he did not enter into anything after serving as Chief Justice of India. He said that once I have been Chief Justice of India, I have no business to accept any other assignment. For judges it's all right, but for CJI it is not appropriate. When he was again offered as the chairman of National Human Rights Commission by then Prime Minister Narasimha Rao, and fortunately I had known him since those days and I have seen him conducting, he said that I don't want to accept this assignment, because I have made a commitment that once I have served as Chief Justice of India, I am not going to accept any assignment. But then Prime Minister personally called him and sent Padmanabhan Nabaya, the Secretary, Home Secretary, and he said, no, I want to meet him. Prior to rejecting this offer, he should meet me once. So he met him and he said, sir, if you join this, if you accept this assignment, at least you can serve. Even if you can save 2 lives, it's like a great thing. Sir, he is fond of reading. And he says that every day you talk about any subject, he has some special knowledge. Even in artificial intelligence, I remember 6 years back, there was a conference in Bangalore. We were participating. When it was raised that, sir, do you think that this courts will function like this only? He said, no. I can see that the courts are functioning virtually. And there were 2-3 other former Chief Justice of India. They said, sir, we are not going to buy this. He said, you see, one judge will be sitting at one place, another judge will be at other place, lawyers will be at different places. Litigants may also observe from there. This is going to come. And sir, unfortunately, this COVID came and those predictions, what he made publicly was found to be correct. I will say at last one thing, that he was fond of education. एक फिराक की लाइन है, वो मैं वेंकट चलैया जी पे कहता हूँ कि आने वाली पीढ़ियाँ जो हम सभी लॉयर्स की हैं, हम लोग को नाज होगा कि हमने वेंकट चलैया जी को देखा था. तो मैं इसके लिए बहुत-बहुत आपको धन्यवाद करता हूँ कि बहुत अच्छी किताब आई आप.
Thank you very much, Mr. Rai, for recounting on some of those very, very unique anecdotes as well. Let me say this, that I was so privileged to be at the National Human Rights Commission when he was the chairperson. Just when I graduated from Campus Law Center in 1997, I didn't become a lawyer. I decided to join the National Human Rights Commission. So I saw firsthand what he did in NHRC as chairperson during 97 and 98. Many people may not know, but because of his personal intervention, India was able to sign the Convention Against Torture. He personally engaged with the then Prime Minister and the Home Minister. But the tragedy is, even after India signing the Torture Convention during his tenure, we have still not been able to ratify it even more than 2 decades later. Another major contribution he did at NHRC was about manual scavenging. The Manual Scavenging Act had already been passed, elimination of manual scavenging. Unfortunately, it was not notified. He again took efforts to ensure that the act is notified. He worked on right to health, maternal mortality and anemia was a major problem. He was at the vanguard of it. In some ways, what he did is lay the foundations of the National Human Rights Commission, which was established in 1993 only. And he, of course, was one of the earliest persons who assumed the leadership. So truly remarkable for him to do that. Let me quickly move to Justice Banerjee. Justice Banerjee, we are indeed talking about the legacy and the contributions of Justice Venkatchaliah. One of the things that comes very strongly is his deep sense of independence, autonomy, and consciousness of his commitment towards speaking truth to power. A quality that you quite rightly said in the form of integrity should be assumed that judges ought to have. Now, without going into details, it is not an exaggeration to say that the issue of integrity, independence, autonomy of judges, even at the highest level, has come to serious questioning and scrutiny in the last several years. My question to you is that, what would you like to say about that trend that is developing, and how do we address it, and what can we learn from the life and legacy of Justice Venkatchaliah?
It's okay. Justice Venkatachaliah is a role model for any judge. I've just said that. Now, so far as independence is concerned, I think independence and integrity, so far as judges are concerned, are interlinked. If a judge is not independent, then he is not going by the oath of office which he takes. Again, I repeat, the basic qualities of a judge are his independence, his integrity, and his impartiality. Justice Venkatachaliah had them all. That was also the advice which he gave to judges. In 2014, he had come to Calcutta. By that time, I was a judge. He had come on the occasion of the formal release of a book on Justice Ashutosh Mukherjee, written by Mr. Sudhish Pai. On that occasion, I had the privilege to meet him and actually share the dais with him as one of the speakers on the occasion. He always advised judges to be impartial, independent. Now, if you say that there is a perception that there is lack of independence today, I can only say that it is unfortunate. But I think judges are by and large independent, at least persons I've worked with. We even have one of the former Chief Justices sitting right across, and we have seen him as a very, very independent judge. There have been other Chief Justices also and judges who are independent, if there is lack of independence anywhere. But there is also one thing. You can't always go by press reports, social media reports, because what does independent mean? Independent doesn't mean that you become the leader of the opposition. And independence doesn't mean that you go by what the government does all the time. Independence means that you decide a case on its merits. If the government is in the right, then you hold in favor of the government. If the government is not in the right, then you hold against the government.
Absolutely, ma'am. I entirely agree with you, and I think the hallmark of a great judge is to be able to function autonomously and independently, but without fear or favor
Yes.
for anybody, be it the government or the opposition.
But then there is also another thing. Justice should not only be done, but it should manifestly be seen to have been done. So if a judge is too close with any political dispensation or persons belonging to any particular dispensation, then if the judgment goes in favor of that political dispensation, then, the principle of justice should not only be done, but manifestly be seen to have been done, gets breached.
Absolutely,
There are exceptions when you have to interact in the course of your official duties. Because, when you're the Chief Justice of a High Court, let us say, when I was in Madras, for funds, you had to approach the government. So once in a while, there had to be meetings. But these were very open meetings. These were official meetings. Other senior judges used to be there. Officials from the government also used to be there. But if a judge is meeting a politician on a one-to-one basis, then it sends the wrong signal to the people.
Absolutely, ma'am. Thank you so much for those reflections. Let me move to Justice Waziri, probably shifting gears a bit. So one of the things that many people outside the legal system, as in those who are not interacting directly with the judiciary, may not be familiar, is the extraordinary volume of work that our judges do. I mean, think about the fact that the Supreme Court of India produces over 1,000 judgments a year. If you look at counterparts in any part of the world, they don't do that much work. And the same thing holds good for high courts and other courts. So my question to you is that, and Justice Venkatchaliah, of course, was very conscious of the delays and the impact of it in the administration of justice system as well. So my question to you is that, how do we bring that into a more sharper focus within the administrative of justice system now, and to what extent today's advancements in science and technology can help us address some of those issues?
Considering our population, we are possibly the most non-litigious nation. Yes. But there will be, people will assert their rights. They'll ask for the freedoms to be upheld. As more and more the courts become accessible and they realize what the Constitution means for them. So if you look at the population to the number of cases pending, it's a very, very minor one. Amongst the various measures in which various judges have tried, Chief Justice have tried to find solutions, is also the solution by Justice Lalit, who's sitting here. In his tenure, he tried to bunch cases together and finish off hundreds and hundreds and thousands of cases, which he did very, very successfully. Technology is, of course, there. Earlier, just moving of files would take so much time to bring the cases to the court. Now, with the e-filing and e-courts, things are much faster. So the time taken in actually getting the case to be heard is shortened. It is easier for litigants to be sitting at home or wherever they may be, for lawyers also to travel. But you look at the number of cases which are pending today, roughly 4.5 crores, if I'm not mistaken, somewhere there. But of them, a large number are check bouncing cases, your motor accidents. So these take virtually half the numbers. And in the other half, if you look at it largely, 65 to 70%, the government is the litigant. Now look at it, where is the meat of the case? Where is the meat of the matter? If you remove all these unnecessary ones, you really don't have much of a pendency, and the judiciary can very well take care of it. But if we are bogged down with simple things like ye kya motor accident ka chalans aa rahe hain, and the check bouncing cases, that suddenly the public thinks, oh, there's so many cases that will never get solved in a lifetime. It's true. There are cases pending for many years. But in the high courts, the chief justices and all the judges are trying to see that cases do not remain pending for more than 5 years. That's an effort being made. 10 years, 5 years, etc. So they don't lose their relevance. And I think technology is helping in a big way out there. No, we were talking about Justice Venkatchaliah. I remembered something just now. The gentleman, you know, you looked at him and he inspired you. You looked at him, लगता था यहाँ इंसाफ मिलेगा मुझे, यहाँ इंसाफ मिलेगा. कोई शक व शुबहा नहीं था. और यंगस्टर्स के लिए ख़ास तौर पे he personified equanimity and fairness both in personal and in public life. He believed that we must be circumspect in our personal affairs and in our public affairs and in interpersonal dealings or interactions. एक वाक़या याद आता है कि he said, you know, when he was practicing as a lawyer about 50 years ago, a litigant, his client gave him what he thought was the appropriate fee. He kept 2/3 and returned 1/3 of it because he believed that the amount he retained was more than sufficient for the services rendered by him. That was the measure of the man, fair to the nth degree. And a person like that, when he occupies the position of the judge, it really reassures the litigant. As Justice Banerjee was saying, fairness is intrinsic. It has to be a part of the soul of that individual occupying the chair. They take the oath. But more than that, the person has to inspire that confidence in the litigant there. It should be seen from a distance. If the judges together, they make the court. जिस रोज़ लोगों का विश्वास हटने लगेगा, तो फिर मायने नहीं रहेगा उसका. Thank you.
Thank you very much, Justice Waziri, for those, I think what you said is so critical, especially for today's generation of lawyers and judges, about the exemplification of gracefulness both inside and outside, public and private. Baram, one of the things that I want to ask you is about the way the legal aspects are dramatically changing and how judges are asked to adjudicate on complex matters. Now, unfortunately, the legal training and to some extent legal education is not necessarily preparing them adequately for the dramatic changes that are happening in the world of law. Law and economics are having a greater impact on several aspects of litigation. So my question to you is that when you are looking from the standpoint of a lawyer and when you look at judges, how do you think we need to reimagine continuing legal education for judges? What ought to be the way the judicial academies need to prepare the judges so that they are better suited to address some of the new and emerging areas of law, because law has dramatically changed, and what lessons we can learn, because clearly Justice Venkatchaliah was ahead of his time, as you mentioned, when it comes to his role in advancing the arbitration aspects of ADR.
Yeah, no, that's a very critical problem. So in some ways, it's the opposite. I said, when you're a junior, soak in and be as broad as possible. And then, of course, at a judge's level, there's no question that you need the broad knowledge and you have the aptitude, you have the intellect, that's why you are there. But in today's world, let me take an area where I have spent a lot of time, so bankruptcy. I think for something like that, to have a bench which has had the benefit of some discussion, I think what we did there, we had colloquiums between the NCLT and NCLAT members and the practicing lawyers and people who were involved in drafting the law, just so that you could have a dialogue and explain to the judiciary what we are trying to achieve. And I think that was very, very helpful. And Therefore, having specialization in those kind of areas, you know, as you said today, competition and bankruptcy and intellectual property, those areas to have that CLE and in an appropriate forum, because I know these are sensitive issues as well, is very, very useful. Because what has happened today, because IBC is getting so much priority, the regular company matters are suffering a lot. So we do need some kind of specialized benches as they have across the world.
Thank you very much, Bairam. Let me move to, sorry, please.
Your question was, what should the judicial academies do?
Yes.
The judicial academies should initiate discussions, which the National Judicial Academy does. They regularly have programs for judges of different levels, for the civil judges, for the district judges, and also for the High Court judges. Now, there is one thing which all judicial academies need to do, they have been doing. Maybe they should take it a little further. You know, we talk about independence, we talk about integrity. But what exactly should be the norms? This is something which should be formulated jointly on a concerted basis, taking opinion of all stakeholders. Of course, the Bangalore principles are there. The Bangalore principles are there. Then you do have the full court decisions of the Supreme Court taken way back in the 90s. But I think with passage of time, a little bit of streamlining is necessary, because the newly appointed judge, particularly a judge appointed directly from the bar, may be a bit confused. He may know that, yes, independence, impartiality, without fear, without bias. But how should he be behaving? To what extent should he be intermingling with the lawyers who appear in his court? To what extent should he be interacting with his former friends and colleagues who might be appearing before him every day? You know, these are areas which require discussion.
Well, thank you so much, ma'am, for those comments. I think all of them are important questions, especially in the context of a lot of young people entering into judiciary, and they may or may not be familiar with those principles that have evolved over the years. I'm conscious of time. We have another 9 minutes to go. So, Mr. Pradeep Rai, my question to you is that, you see, one aspect of Justice Venkatchaliah's contribution, which I think is quite remarkable, is the fact that he also remained a public intellectual. He not only confined his work as a judge, but the heart of his interest remains the true advancement of law, where even after judicial work, he continued to do so many other things. He was actually actively involved in the Center for Governance in Bengaluru. You mentioned about his contribution in the field of education. Much later, after NHRC, he took up the leadership of the National Commission to review the working of the Constitution. And quite remarkably, I remember very well that when there was some fears and concerns expressed by many members of civil society about the purposes of this commission, the fact that it was Justice Venkatachaliah who was chairing that sent a lot of, let's say, positive signals and assured people that the intent of that commission and the work of the commission itself is nothing but purely beneficial for advancing the law itself. And those reports are absolutely fantastic. So my question to you is that, essentially, how does a judge sort of evolve himself or herself into a public intellectual much after leaving the world of law and justice?
You see, Honorable
Yeah, you can keep it closer to you.
Yes, Honorable Justice Venkatchaliah, when he was Chief Justice of India, then and there also he worked on few things: administrative competence, collegium system, on which I remember one incident when late B.L. Hansaria, whose son Vijay Hansaria is also senior advocate in Supreme Court. He was Chief Justice of Odisha, and he was very close to Honorable Justice Venkatchaliah. So once he visited Supreme Court and he said that you did not do anything for me despite all the competence that I deserved to be appointed as Supreme Court judge, you did not do anything. He said, if you deserve, you would have got. So if you don't deserve, you will not get it. Then he left, he went to Justice Ahmadi's room, who was then the number 2. And Ahmadi congratulated him that, Mr. Ansaria, you have already been cleared for Supreme Court. He said, no, but Justice Venkatchaliah did not inform me. He said, no, but we had cleared day before yesterday your name. So that kind of person he was. Other than this, what you were referring, he was such a person that if there is anything academic, intellectual, religious, and not only to Hinduism, about any religion, about any kind of writing, about any kind of concept or jurisprudence, he was such a person, and still he is such a person that he will like to interact, deal with it, and he keeps updating every day. If you talk to him, you will feel like that he is a scientist. Sometimes you feel like that he is an academician. Sometimes you feel that he is a man who is completely socially connected with each and every one. And sometimes you feel that he is a man who is expert of human behavior. I remember a few incidents when he was in National Human Rights Commission. We traveled a few places together. Even when he goes to a prison, he will try to see that how many plates are there, how many spoons are there, whether each and every inmate is getting one plate and one spoon, and by surprise to everyone that it was only 1/4 of the strength in the prison. So it was the great contribution of his that he did the prison reforms, he did educational reforms. He tried to, suppose a student writes a letter, like I, as a young journalist those days, when he was in Supreme Court, just by writing a letter, you could meet him. And he was such a person that he will try to educate you. If you are not agree with him, he will not mind. I am fortunate that recently there was a training program of mediation. I requested, sir, that, sir, tell me what we can do for the knowledge of lawyers and improvement of their academic skills and updating themselves. He suggested me that there are judicial academies which are working only 50 to 60 days in a year, despite all the infrastructure. Why don't you ask and request the Chief Justice to give you those facilities and utilize that for the benefit of lawyers? I am thankful to Justice Ramanna and Honorable Justice Uday Lalit, who is present here. Justice Lalit sir, especially for you. So we requested Honorable Justice Ramanna and Honorable Justice Lalit that we need to be trained in the mediation, and especially we wanted Judicial Academy. I am thankful to Honorable Justice Lalit that he extended all the help, and our training program, which was the record 250, earlier only 50 mediators were there in Supreme Court, but those 250 mediators came in National Judicial Academy and Delhi Judicial Academy. I am thankful to a suggestion of Honorable Justice Venkatchaliah, and I am thankful to the great efforts made by Honorable Justice Lalit for training those lawyers. Though we treat him from the bar only, he is I never treated him as an outsider. He has been a member of the bar. He is still our elder brother and our great support for all of us.
Thank you so much, Mr. Rai. Of course, I will call him as Professor UU Lalit for his contributions to our community. We're going to have only 5 minutes now, so I want to throw it open for the audience. We'll take 2 questions, and then I'll get back to our distinguished panelists here and take their responses. 2 questions. Can you please stand up and ask your question, introduce yourself quickly? Even if there's no mic, you can come up and please ask the question. I'll pick it up. I'll collect two questions and then together they can answer. Yeah. All right, please.
Yeah, okay. Hi, I'm Nitish Raj. I'm in fact an alumnus of OP Jindal Global University and even international law firm Nishit Desai Associates. I practice at Supreme Court. So it's not a question, I just thought of sharing one trivia which we all might have missed while we were discussing former Chief Justice Venkatchaliah. The trivia is just, since most of us in the audience are counsels and those who are in councils, they either aspire for a senior gown or a partnership. So he was he relaxed the requirement as there was an age requirement for the senior gown for two eminent counsels who later served as Solicitor Generals, Mr. Gopal Subramaniam and Mr. Rohinton Nariman. In fact, that was his magnanimity that he saw something in their court craft and court etiquette and relaxed the requirement for them to become a designated senior counsel by the Supreme Court. So I just thought of sharing this trivia which
Thank you.
with all.
Thank you very much. There's one question behind and then we'll wind up there. Yeah.
Thank you, sir. Thank you for this opportunity. My name is Rishabh Sharma. My question is that in the time when the Supreme Court of India is seeing so many constitutional matters, especially touching the society, for example, Sabrimala, LGBT, and it's a matter where a lot of evolution of jurisprudence happens. So how do judges balance this jurisprudence and give out the decision on merit?
Great. Thank you very much. So I'm going to request each of our distinguished panelists to spend 40 seconds in your closing comments. Over to you, Justice Banerjee.
In an adversarial system, the lawyers have a great contribution. They make their arguments. The judges hear the arguments. They are supposed to have a good grounding in law. They go back and read, decide, try to appreciate what is an issue, and then lay down the law. If that is the question. That was the question.
That's fine.
I think, as you said, they are difficult issues, and we live in a very dynamic society across the world. But after all, the judiciary is one of the key three pillars, and therefore it has an extremely important role to play. And as long as it doesn't usurp the legislative function, its importance is just super crucial.
See, for a judge, or for a litigant, for the ordinary person in the society, it's important for him to carry the impression that I was heard. Most important is that the person was heard. And then the judgment follows, the decision comes. Very often a counsel may not be able to convey what are the various contours of the matter. It is at that time that the judge has to listen to the silences that I've said. To listen to the silences, वो बात जो कही नहीं गई, वो मुझे सुनना है, judge को सुनना है वो. And that's where the balancing comes. You listen, you look at the entire matter, it requires some mulling over. Tamam cheez ko, you have to look for the balance there. And that's what all judging is all about. It's the same thing in your daily life. Somebody comes to you with an issue, you have to look at it and be fair. Fairness should come out from your judgments. Thank you.
Thank you. Please.
Once a question was put to Lord Chancellor that what takes to be Lord Chancellor. And he responded that a judge should be gentleman and he should know little law also. I feel that the quality of being a gentleman is necessary among the judges, and also it is similarly important among the lawyers. If we have all this, our system will certainly strengthen and the justice dispensation will be absolute.
Thank you very much, Mr. Pradeep Roy, Justice Waziri, Justice Banerjee, Bairam, as well as Abhishek Singhvi for a fascinating panel. Congratulations to both Vivek Debroy and Samir Kocher for producing a beautiful edited book. It has 17 essays, 7 of them on the theme law, and then another 10 of them on life. It straddles across different aspects of law. I want to end by citing absolutely fantastic observation by Justice Holmes when he said that the life of law is not logic but experience. And I consider Justice Venkatchaliah as the Justice Holmes of India. When Justice Holmes retired, the entire court wrote a note, signed together about his contributions. And I want to read that note, and I do believe that Justice Venkatchaliah epitomizes so much what was said by his colleagues, Justice Holmes' colleagues, when he retired. And I will quote it. Your profound learning and philosophic outlook have found expression in opinions which have become classic, enriching the literature of the law as well as the substance. While we are losing the privilege of daily companionship, the most precious memories of your unfailing kindness and generous nature will abide with us. And these memories will ever be one of the choicest traditions of the court, unquote. I strongly believe that the peers and others who work with him, and generations of judges whose lives he touched, generations of lawyers whose lives he touched, would have the same opinion about Justice Venkatchaliah. So it's a fantastic tribute to an extraordinary man, a living legend, and a far-sighted jurist. Thank you very much, Coach, for this opportunity for me to moderate an absolutely wonderful panel. Thank you. Yes, of course, I want to take this moment to congratulate the publisher, Oak Bridge, for producing the wonderful book that we have with us today. Thank you.
Last year also, I think they brought out a book on Justice Venkatchaliah, Oak Bridge. Congratulations to Oak Bridge.
Thank you so much, each and everyone who is present here on the days, and thank you so much for this wonderful discussion, indeed an enlightening one. And now I request all our distinguished people here to kindly gather in front.